Hello everybody, it's Dave Neal, stand-up comic, host of Bachelor Nation News. In this video, I'm going to share with you the 40-minute court hearing that is Eckerd v. Jane Doe from February 21st, 2024. We're going to jump right into it. Follow me on Instagram at DNeals. I'll be live after this on Patreon, patreon.com/Dave Neal. I'll give you some updates on the documentary in the works regarding this court case, which of course is ever unfolding, and we're going to get to whatever shocking, content comes from this. Of course, we've had court reporters reporting on this. We were live on the scene last week. Wasn't that crazy? But now we can watch with bated breath as we see both Woodnick and Jane Doe's lawyer duke it out, as it were. And don't forget, if you want comedy, because this is just a tragedy, really, but if you want comedy, March 28th, I'll be at the Desert Improv in Phoenix, Arizona, and I'll have special guest Clayton Eckerd. So you can go buy tickets to that right there. All right, there'll be a link in the description below, or you can go to my Instagram and click on the link tree to buy tickets to that. We'll have a little party after. It'll be a ton of fun. All right, I'm going to try my best not to interrupt too much, or at least not to pause this, and we're going to get right into it right now. Here is the February 21st court hearing. It's 40 minutes long. It's actually interesting. It starts off by the hot mic catching, I guess, Jane Doe and her attorney discussing, I don't know, are they flirting? A lot of people are wondering. Oh boy, be careful. Have a listen. Do you hear that?
Nice. This is a nephew. Always different. Oh, that's fine.
Oh, so Cal.
Travel sucks when you have to go to the same place.
Travel sucks,
Yeah.
it says.
Worst.
At least with California, it's nice because I can just drive.
Yeah.
So,
She says she can drive,
It's always good.
which people, by the way, are wondering, due to her medication, they say she wasn't allowed to drive, but she says she can drive to California.
Usually,
especially in the summer.
like, can I travel for 2
I'm
months?
like, exactly.
They're laughing. They're having fun. All right, so the judge is there. They all rise. We've got Corey Keith on the left, Woodnick on the right, dear Princess Isabel Rainey, the other attorney, their power attorneys, and Greg Gillespie behind them watching the case, and a couple power listeners.
Seated, please.
All right, let it begin.
Good morning, everyone. This is the time set in FC 2023-052-114. Appearances, please. Beginning first with Petitioner's Counsel.
Morning, Your Honor. Corey Keith appearing on behalf of Petitioner Laura Owens. Myself and client are both present, appearing in person.
Good morning to you both, and from the respondent.
Good morning, Judge. Greg Woodnick. I've got Clayton Eckerd with me, and my associate Isabel Rainey is behind me.
Good morning to all three of you. All right, this is the time set for status.
Morning, Dave Neal here.
Parties vote no. A motion.
Power recapper, Dave Neal here.
Mr. Woodnick, that was your motion, so I'll allow you.
Member of the Professional Society of Journalists here.
As the court is aware from the meetings, we have zero disclosure. I don't think zero is an understatement. I did speak with counsel in the hallway. He indicated that disclosure was forthcoming, maybe as soon as later this week. I'll believe it when I see it, but in any event, we are not prepared to go to trial next week on any of the remaining issues because we have nothing. I'm asking the court to reset the trial for 45, 60 days, whatever the court's availability is, and I'm asking the court to give us 2 hours. Petitioner invoked Rule 2. I'm stuck with it, and I intend to present a case that has foundation for evidence, and her deposition, I think, is scheduled for March 1st if she appears. As
Friday.
Your Honor is aware, petitioner failed to appear at her first deposition setting without leave of court. So I've got to deal with that as well. So we're asking the court just to reset the trial in a couple of months, and hopefully beginning today, there's discovery compliance, and the issues of attorney's fees and sanctions, I think, have to abide trial. And I think that's where we are from our perspective.
Okay, and what time on March 1st, counsel?
Great question, Judge.
8 a.m.
8 a.m.
This morning.
My office.
All right, counsel.
Thank you, Your Honor. Your Honor, we're not opposing the motion to continue the trial. We're in agreement with the need for the continuance on the trial. I did want to address, we received a ruling regarding our motion for confidentiality this morning. There has been new evidence, threats to my client's life that were made to her on Facebook since the pleading practice regarding the motion practice regarding that motion for confidentiality. So I did want to have the opportunity to address that with the court, assuming that the court's position still remains the same with regards to that motion. I did indicate to Mr. Woodnick we will have discovery forthcoming by the end of the week with relation to my client's pregnancy records. Discovery has been requested far outside of the scope of what I believe is appropriate, and so I was hoping to be able to address that with the court as well today.
Okay. All right. So we'll deal with the motion to continue first, then we'll deal with re-urging on the confidentiality and the discovery.
Understood.
Any final thoughts, Mr. Woodnick?
No, I certainly have argument on all of the confidentiality issues, and I think Your Honor ruled on it, but I'll save those for later this morning.
All right. All right. The court will grant the motion to continue. The court is going to vacate the hearing. I believe we had set for the 27th. Yes, we're going to vacate the evidentiary hearing set February 27th at 4 p.m. The court will grant the request to extend the hearing time to 2 hours. I wish I could accommodate 45 to 60 days. We're setting out much further than that, which I apologize for. But Layla, what's our first available 2-hour setting?
It's going to be June 10th, Your Honor, at 8:45.
So Layla's the assistant. Is that how it works?
So that would be in person again.
All right. So essentially, we're not going to get cross-examinate. This isn't a trial. This is just their chance to swap notes. Clayton's looking at his phone, probably seeing that we're all live streaming this. Now they're all putting.
Confirm that was 8:45 a.m.
Yes.
I do that because I generally meet with counsel back in chambers for the first 15 minutes, but I don't want that to interrupt any testimony time. So that's why I said it then.
Understood. And that date and time works for me, Your Honor.
All right. Does that work for you, ma'am?
Yes.
Highly competent judge here.
Sarah, does that work for you?
Yes.
Okay. All right. So we'll set that then for June 10th at 8:45. Now, with regards to the re-urging of the confidentiality motion, counsel?
Your Honor, my client received Facebook messages on February 7th. Prefer not to read them out loud. I did show them to opposing counsel. I'm happy to show them to Your Honor as well.
The messages are that someone threatened her on Facebook. We're still trying to figure out who that person was. Some wonder if it is Jane Doe herself. No one knows for sure. That happened the night that she decided to drop her charges against me, and the beat goes on.
The conduct has just gotten increasingly more concerning from the public. There almost appears to be some sort of obsession with this case.
The obsession from the public is that they're seeing somebody pee on their leg and tell them it's raining. That's the obsession from the public. They don't believe Jane Doe. Almost 100% of the people, dare I say 100%, I've never seen a landslide like this, believe that Jane Doe made up her pregnancy, which is one of the worst things you can do, is weaponize something so sacred as the birthing of a child.
And I think my client, rightfully so, has been nervous to participate in things like the deposition or, giving up her privileged medical records because of this increasingly concerning conduct.
One person.
Can I approach and?
Sure. Mr. Woodnick, you've seen these?
Sure.
So he's showing the messages from the crazy person who, by the way, could have been Jane Doe. We do have sources that have told us she has made up social media accounts dating back to 2015. We don't know if this means she made this up, but one can speculate that it is a possibility.
Voicemails and things of that nature that my client had received. Nothing directly threatening her life at that point, but obviously after the motions and reply were filed, we started to receive these messages, and so she's just concerned that things are going to continue to progress.
Meanwhile, others are concerned for their safety against her. You know what I mean?
And Your Honor, I'll just note as well, the person who's referenced underneath the comment that was made is my client's mother. And then I think they're trying to send over her identifying information as well. Some sort of insinuation that they know where she lives and things of that nature.
But by the way, they shared the wrong address, and Jane Doe left that up for days. She left the threatening note up for days in the same way that Jussie Smollett left the noose around his neck.
Thank you.
Almost as if the way you over-exaggerate rubbing a belly here. Just looking at it from a skeptical eye.
Okay, counsel, I'll let you come and retrieve those. Counsel response?
Judge, a couple of things. Number one, in correspondence to Mr. Keith, I asked for some of the foundational information from that. Whoever wrote what they wrote on that allegedly to Miss Owens is not my client. He didn't do it. He's not involved in it. I appreciate that that's not the suggestion here. Whoever wrote that, it's inappropriate, but certainly not a reason to enter confidentiality orders or any sort of sealing, which I assume is going to be Mother's next in the court, that these are both public figures. And I think that the First Amendment doesn't matter.
All right, so there we have the First Amendment argument. They're both public figures, and one death threat from another person who's not Clayton doesn't warrant confidentiality.
Anyone who might be mind, please mute your phone or your tablet. Go ahead, counsel.
Gee, these
These are both.
people are online. Mute your phones.
My ADD does not do well with those
No,
noises.
it's
Thank you.
Would Nick?
Judge, these are public people. My client wasn't behind whatever that text was. Frankly, there's a level of incredulity regarding that. I'm not so sure that that text is actually real, and it wasn't generated to create an argument to seal or for the confidentiality issue. I can tell Your Honor that we're going to treat.
Wow. He says, I don't even believe that text message is real. I believe it might have been generated for an argument for sealing this. Wow.
Ms. Owens records if she by them. In this case, it's now 7 months along, as we are supposed to, pursuant to the rules. Just like I'm going to treat her as we're supposed to when I depose her in 2 weeks. But I certainly don't think that some random Bachelor fan maybe put a really inappropriate text to Miss Owens maybe is a warrant for the court to do anything other than remind everyone to act professionally, which has always been my intention.
Thank you. Final thoughts?
All right. Agree with Mr. Woodnick in part. This isn't his client, in my opinion, that's making these statements. However, when you couple the statements that are being made that appear to be getting progressively worse with the instances that were cited in our reply, the civil welfare checks that were sent to her home, the calls to her personal cell phone, when you couple all of these things together and look at the fact that they're getting progressively worse. And
people argue that just yesterday on her Facebook, she shared her cell phone, for business purposes, but it's not like she hasn't put that information out there
my
publicly.
client is now being essentially compelled to produce documents pertaining to her medical history.
What a shame. She's being compelled to produce documents as if Clayton wasn't compelled to defend his innocence.
We don't anticipate this getting better, Your Honor, and my concern is that as this continues to get worse, we start to continue to talk about the safety of the parties involved. I understand that we're talking about public figures to an extent. My client has taken a significant step back. I don't know if, in my opinion, I would classify her as a public figure. She maybe is making statements now to try to defend herself and defend her name. But, Your Honor, my concern is...
She's making statements to defend herself and defend her name. When Clayton makes statements to defend himself and to defend his name, she calls the fucking police.
That if this continues to worsen, and like I stated in my response, we don't know what state it's going to get to. We also have witnesses that are afraid to come forward to testify on my client's behalf because they're afraid of what's happening to my client and her family. And so for those reasons,
No witnesses. We have yet to see a witness. Not one witness, not one person privately that is a source, except for Jane Doe's mom. That's it. Who may be complicit.
It's worth at least requesting that the court reconsider the ruling on the motion for confidentiality.
Thank you. Okay, the motion to reconsider is denied. However, we will have the minute entry reflect that Arizona, it's ARS Supreme Court ruling 122 is in effect, meaning all media requests must be through the Maricopa County Superior Court. There are statutory requirements that include using audio only for witnesses, fuzzying people's face out, things like that, that could give some assurances of either anonymity or...
I love it. The judge says, we can blur out their voice. We can only share their blurred out, you know what I mean? We can give them anonymity. Well, I don't know if we need that. I mean, come on. The witnesses, they don't, you know what I mean? The anonymity, shut the fuck up. Bring the witnesses in. We got time, baby. We got time for all the witnesses.
Whatever else may become an issue. I agree the court has absolutely no control over what people post online. It is absolutely inappropriate to threaten people generally.
True.
So the court doesn't condone that behavior. However, I don't think at this point it rises to the level of designating anything confidential. So I'm going to affirm my prior ruling on that, recognizing that there may be evidence presented.
I wouldn't be surprised if I wouldn't be surprised if Jane Doe were the type of person that would spray paint hate speech onto her own house. Do you know what I mean? That wouldn't surprise me if that was the type that we know people have done.
Trial that will require certain exhibits be deemed confidential because of their medical nature or addresses or other things. So the parties need to be prepared to tell me which exhibits at trial need to be designated as confidential, and I'm more than happy to do that. Now, counsel, you also said there was an issue with discovery.
Yes, Your
Please,
Honor.
tell us.
Your Honor, my client understands the court likely in need, based on the recent ruling, for her to disclose things like her medical records pertaining to the pregnancy. It's been mentioned in the pleadings that opposing counsel has requested that she sign HIPAA releases. Opposing counsel has also sent requests for production of documents. Those HIPAA releases request 5 years of her medical records. Under the recent Como ruling back in 2022, we don't believe that that's appropriate. We believe and are asking the court to order that while she should comply with requests for her medical records, it should be pertaining to the pregnancy, the only issue that's outstanding in this case. And on that note, Your Honor, there were 2 rulings on my client's previous motion to dismiss, one which granted in part and left open the issues of attorney's fees and sanctions, and one which I received yesterday, which just outright denied the motion. And so I just wanted to make sure that we were still only talking about attorney's fees and sanctions. And if that is the case, I believe that my client's medical history pertaining to whether or not she was pregnant in this matter is what would be appropriate and relevant for the court to have testimony on.
I'm sure what Woodnick is about to say is, we believe she has done this in the past, so we would like that information to prove that it's a repeat offense. I don't know if I'm right. That's just what I think.
At the upcoming trial.
Okay, before I get to you, counsel, and then obviously you'll have final thoughts to go back to that, the court's intention was to deny the motion to dismiss at this time. So that's the ruling that stands. Mr. Woodnick?
Judge, I appreciate the Como decision, and I appreciate Mr. Keith's argument. The problem is the nexus of our Rule 26 issue, which is that the entire action was filed in bad faith, is not a fishing expedition under Como. Como was designed to stop parties from fishing expeditions. That's not it. We are looking very specifically for the mental health and medical records that would explain why someone would fabricate a pregnancy, why someone would appear in court in front of Judge Gail Ketsis with a 24-week abdomen, tell Judge Gail Ketsis that they were pregnant, and then magically the babies are gone. And I think in order for us to do that, we have a right to get the relevant mental health records and the relevant medical records. And I also remind the court that that does include the fact, as we've pled here, that there's a history of the fabricating behavior. That's actually the nexus of our Rule 26 motion. For Rule 26, which, to make a clear record, is really Arizona Family Court adopting Rule 11, Civil Rule 11, not Mental Health Rule 11, but Civil Rule 11. And it addresses the propriety of filings and the propriety of signing filings that were signed by Ms. Owens directly. And she filed them, and then she filed multiple filings after that. And every single one of those filings made claims and assertions that this court has an absolute authority over. In order for us to defend or produce an argument regarding Rule 26, we need to have those records. We will treat them appropriately. They are not going to be publicly shared for any that we have any intention of doing at this point, but it's going to be part of a very public proceeding because Ms. Owens, as recently as 4 days ago or 3 days ago, published an article about these very issues. She's made it pledge. She's the one who went to the Sun tabloid claiming not just that she was pregnant by Mr. Eckert, Judge, but that she was pregnant with twins and posted a visual of the twins that she was pregnant with. We have a right to all of the discovery relevant to that for the attorney's fees issue, for the sanctions issue, and for the integrity of Title 25 and the mud that Mr. Eckert's been dragged through. I'm not interested.
Wow. I mean, he just held up the sonogram. Oh boy. And what we know from the previous case with Greg Gillespie sitting right behind Greg Woodnick here is that she would taunt Greg Gillespie. Oh, you're going to be a great father. Oh, looking forward to this. Oh, happy Mother's Day's coming around the corner. You know, she taunted him. She weaponizes this fear that men have that they're going to be stuck with her and tries to get them to sign contracts and this and that. So Woodnick says, I think we have a right to look into the medical records. Woodnick brings into the account whether or not she's got a mental health problem here. I mean, he's not doing it with any malice. He's just saying, hey, you know, he's cool, calm, collected. I'm not a judge, but I'm just, boy, this is like boys versus men here. He's the man.
And her childhood trauma. That's not relevant here. I totally agree with that. But Rule 49 does specifically say we're entitled to 5 years of back records. And I think asking them to be produced is reasonable. I also remind the court as my final comment, they've provided nothing. When I say nothing, Judge, I mean no medical records, no financial record. I mean nothing. Even the stuff that is not even controversial, like legal fees. Zero disclosure. So to come to court today and say, oh, no, we want to rein in the disclosure is a little bit disingenuous. They should have been providing records along the way because that's what Rule 49 required.
Thank you. Counsel, do you recollect when the first filing was that would necessitate records back that far?
Yes, it would be 2021 February.
Wow, he looks back to Greg
August
Gillespie.
2021. Okay. Final thoughts, counsel?
Your Honor, just to be clear, discovery has been transmitted, albeit minimally, because my client has been afraid of the backlash that would occur. My client did send Mr. Eckert
Minimal. We've given them the discovery, albeit minimally. Little to no discovery.
Pregnant. She sent him over the results of her blood testing. She has sent him over documents. I believe that the evidence will.
So this is where it gets confusing, right? We're going to pause it right here. He says she sent over the revolt. He said she sent over the results of the blood testing. Let's listen one more time.
Results of her blood testing. She has sent him over documents. I believe that the
So the question is, what is in those results?
confirmation that she was pregnant. She sent him over
So what he was this might be the biggest slip up that we have. Maybe it's an innocent mistake, but he was gonna say she sent over HCG, which is a hormone, which doesn't mean you're pregnant. The hormone could lead to pregnancy, or for someone who's not being malicious and abusing the system, one who's got high HCG might be pregnant, but it doesn't mean it. Listen one more time.
Mr. Eckert confirmation that she was pregnant. She sent him over the results of her blood testing.
She sent him over the result of his blood testing. I think that might be the biggest moment here. What did she send over? And when he gets a chance to cross-examine and find out at the deposition, we'll get to see.
She has sent him over documents. I believe that the evidence will show that she was pregnant. I believe that will be clear once everything is presented to the court. And I don't believe that it would be appropriate for her to have to disclose records dating back to January 1st of 2018, as the respondent is requesting, addressing her anger management, substance abuse, domestic violence, and additional things. This is a fishing expedition. This is what's covered under COMO. The difference is we don't even have this situation under COMO, Your Honor. We have a situation where there is no child. There are no best interests of a child to be considered. We have a situation where the respondent is on a fishing expedition. He's trying to pull things in and twist stories of previous incidents against my client.
Yeah,
seem like
he's trying to find the smoking gun that she was never pregnant. If you want to call it a fishing expedition, they're fishing for the fucking truth. And boy, are they about to pull it in.
Fabricating these allegations, when the reality is, and like I said, I believe the evidence will show this, my client was pregnant. She did have a miscarriage. She's no longer pregnant. And I believe that the evidence will show that. And so for those reasons, we're asking the court not to allow this fishing expedition. They're requesting documents dating back to January of 2018. This is absolutely should be covered under COMO. And I believe that the court should actually look at this even further because, like I said, there are no best interests here to evaluate, to overrule my client's medical patient privilege. I understand that my client has an obligation to prove her pregnancy, and I think that it's in her best interest to do so as well. But to allow the respondent to go back 5 years into her domestic violence history, her substance abuse history, and obviously assuming that there even is any, it's just absolutely inappropriate. And this is a fishing expedition.
This is my first time hearing about substance abuse, which again, if you have abused substances and if you do have mental health issues, it would become very clear when fraud is proven that you're going to foot the bill. Not a fishing expedition. No fishing happening here. Maybe a harpoon. They know exactly what they're coming for. Fishing would be, oh, let's cast a net and go fishing. Woodnick is targeting spear fishing right now. He knows exactly what he's going for, metaphorically.
So you said your client did provide limited disclosure. Did that include evidence of the miscarriage?
No, Your Honor. The miscarriage came further throughout this case, and the records that outline the miscarriage and her going to the doctor after the miscarriage have not yet been sent.
Oh, okay.
And when are
Your Honor, all of my client's medical records pertaining to the pregnancy will be sent to the respondent by the end of the week.
It's almost as if the judge wants to ask more questions, but she's like, I don't want to do Woodnick's job for him. You know what I mean? The judge is so curious. She's like, well, so you shared that she miscarried? Well, no, we didn't do that. So, and the judge is like, you know what? We'll let this play out. I wonder if the judge has any maybe popcorn coming in the background.
Waiting on a ruling on the motion for confidentiality because we have concerns that by next week they'll be released to the public.
How would they be released to the public, counsel, if they're just exchanged between counsel?
Well, Your Honor, I believe that they would also be sent to the respondent, and I can tell the court that even my own emails to opposing counsel have been, in this case, released to the public. I'm not insinuating that that is... No.
That's not true. The only emails that have been acquired and published are emails that were in exhibits. That's not true, I don't think.
But Nick, I understand he has an obligation to share the documents with his client, but the reality here is documents that are being transmitted, pleadings that are being filed, emails that are being sent between the parties are being released to the public in a manner of hours, not even days, certainly prior to someone's ability to pull pleadings online. Also of note, those pleadings that are being released to the public are being released in color. I believe it's common knowledge that when you go down to the courthouse and request documents, those documents come back in black and white. So it's clear to me that there's some sort of a leak to the public. It's why we filed our motion for confidentiality, and I don't believe it's appropriate for my client.
They're seeing it in color. I mean, I understand what he's trying to say. He's trying to say Woodnick's leaking them because they're coming in color. I get it, but it's like, this is the problem. It's almost like, how about we just let the truth surface? How about that?
Records dating back to 2018 to be dragged through the public.
All right. When did the miscarriage occur, counsel?
Your Honor, I'm not sure that an exact date is known.
What month?
The judge. All right. So now, okay. So how the hell does he not know what month it took place? Oh, we don't know the date. A time period? Was it, what quarter? Was it in the spring, the fall? Were you an adult? Were you alive? Or was this a dream sequence you were having on ayahuasca? I love that the judge is like, all right, give me a time. And then Corey Keith has to go to his client, so he doesn't even have the answer. I don't blame him, but the fact they haven't discussed this. Get your story straight before you lie to people's faces.
An exact date is known.
What month?
Wow. They're about to find out.
I believe my client went to the doctor in mid-November, and that's when it was determined that she had had a miscarriage. We would believe that it was in the maybe month or 2 months leading up to that time.
So previous counsel should have disclosed that.
Woodnick's pissed.
Well, Your Honor, I believe that the increasingly concerning nature of this case and the request.
So the judge says, wasn't she supposed to tell you this? Shouldn't she disclose in this case that she had a miscarriage? Now, Woodnick's looking back on, what do we even do with this? I mean, how do you play chess with a buffoon? You know what I mean? This isn't even like a fair fight at this point.
For confidentiality and the request for the dismissal, I believe that given the fact that everything my client sends to respondent is being shared with the media, believe that warrants at least some degree of the court finding her actions to be reasonable. She is actually receiving threats to her life, voicemails on her phone. I mean, this is concerning conduct from the public. And so we were just waiting on, same thing with the deposition. I told Mr. Woodnick we would appear for it.
We didn't want to share the truth because consequences, now again, not death threats, no one wants that, but consequences of an audience that's angry at her. We didn't want that. We called this from a mile away. We've been saying this since like October, that she's going to claim a miscarriage. And then once the 20 weeks hit, we said, well, she can no longer claim a miscarriage. And then I said, well, what she could do is say the miscarriage happened back then. She just didn't report the miscarriage. Ding, 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 ding. Bingo. That's what she did.
Deposition, if the court ordered us to, we just wanted to have the motion to quash and the motion for confidentiality ruled on prior to doing so, because we wanted to have the court's input into if those things were necessary.
And the court gave you its input, which is the court continues.
My follow-up question to you then would be, if she had disclosed it in November, wouldn't this case have simply gone away and these issues wouldn't remain?
Well, no, Your Honor, because she did disclose the fact that she had a miscarriage. It's well documented in our pleadings. I understand that the medical records...
Look at Clayton. Clayton's going, are you kidding me right now? Everyone's like confused. They're like, is this even, what the hell? By the way, shout out to the audience member that has a Dave Neal merch shirt on. Link in the description below if you want to buy merchandise before the June 10th court date. Hey, anyone can wear merchandise they want. I heard one of the security guards gave someone a thumbs up for wearing Dave Neal merchandise.
Either, but my client does have a patient. She has privileges that in this case are not only being not considered or not fully considered, but it's being taken even further, and her documents are being, I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that. I understand where the court is coming from, and I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents, and we've had some discussion about that.
I've seen more transparency with alien sightings. Well, we've offered to show people the aliens. Come in and check the aliens behind the glass. You can't touch the aliens. Like, no, if these documents should be available for scrutiny.
Obviously, the recent pleadings, I think, may change that from the court, but it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
All right, we'll have the minute at agree reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways. I don't want anyone releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways, and truthfully should go without saying, but I recognize it does not in this case. I am going to order that the
But here's the issue. Here's the issue. She's going to lose, and if the public doesn't get to see the evidence that made her lose, she's just going to lie afterwards and say, well, blah, blah, blah. What needs to happen is she needs to, if she loses, it's almost like when you lose a defamation case and then you keep on defaming someone. If you lose a defamation case and keep on defaming someone, you should have to continue to pay and pay and pay. So the audience needs to see, in a very limited scope, the evidence. And it doesn't mean they need to see 10 years of her medical records. We don't need to know what genital rash she might have gotten in college or anything crazy like that. Although she did, I think, went to online school, which would make that weird. But I'm just saying, no one cares about that. It's what evidence did you use to slander and defame Clayton by saying he was a shitty soon-to-be dad? What evidence was that? And if it doesn't hold up, I think audiences need to know that.
Dating back to August of 2020. That's 1 year prior to the first filing. I think that's appropriate. Mr.
Wow,
Woodnick,
Clayton's nodding his head. So they're giving all of the records to Woodnick here. 1 year. So Woodnick said, we would like the records starting in 2021. And then the judge said, How about this? I'll give you a year before then, just to see whatever the hell happened leading up. Maybe the judge believes, X-Files music, maybe the judge believes that there was fertility drugs or HCG treatment or something going on that would have led her to test positive when she actually wasn't. Fascinating that the judge would ask for medical records 1 year before Greg Gillespie. We're getting nearly a half a decade of medical records. Again, I don't need to see it. The judge can decide what to seal and not seal, but important that the right people, the decision makers, are getting to see the truth.
Have a release with you today that she can sign.
I've sent that.
This outlines that it would date back to 2018, so I believe we need to
Redline it. That's fine.
If you'd like to adjust that, and then we can sign that and have that done today. You can do that now.
Judge, on the discovery issue, if I may.
Sure.
I appreciate Your Honor's ruling. Obviously, I'm assuming if there is something that comes out in those records that requires us to seek leave of the court to expand that, we can readdress that with the court. If something is in those records that imagine getting part of a medical record because of the date issue, we'd be able to come back to the court and address that if necessary.
Both parties always have that right.
Secondarily, appreciate that Your Honor's not living this case every day, but the testimony, not the testimony, the statement of counsel was just that mother says she had a miscarriage 2 months before November. In November, the parties appeared in front of Judge Gail Ketsis, where mother had a pregnant belly and told Judge Gail Ketsis she was 100% pregnant by my client. Your Honor's not adjudicating that today, but I'm asking Your Honor to take back the protective order proceeding that was granted in my client's favor for purposes of not consolidation, to be heard concurrently for the purposes of attorney's fees and sanctions on that matter. Because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding, then I think that's sanctionable and Your Honor could enter orders under that proceeding. So I'm asking Your Honor to take, not jurisdiction, but to hear that matter concurrently or to have that file available for our upcoming evidentiary hearing.
Response?
Your Honor, I would ask the court to deny that request. Spoken to experts in this case preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. I'm not saying that that is the circumstance here. I certainly wasn't present. Saying that my client has not lied in this case. She has not intentionally lied to the court. Whether or not she was pregnant on that date, I think she could have testified that she was pregnant and she could have had a miscarriage days prior. I don't know, but I believe that the testimony in her deposition, the testimony in her final trial, and the expert testimony that will come with it will make those things clear. I believe it'd be absolutely inappropriate to throw out previous proceedings in this case based on my statement, not even my client's statement. There would need to be an evidentiary hearing in order for that to be proper.
But I think that's what he's asking. He's asking that the evidentiary hearing be wrapped into this.
And Your Honor, that's not appropriate. The evidentiary hearing has already been done. And like I said, my client's statements that were made during that hearing were true to the best of her knowledge. The reality here is sometimes women believe that they're still pregnant when they've had a miscarriage, and they don't know until they go to the doctor that their levels are no longer appropriate for a pregnant woman.
We've actually spoken to a miscarriage expert, someone who, works with universities and is a doctor. And they said this is patently untrue, that you could have a miscarriage this late in a pregnancy, 5-6 months with twins. Early on in a pregnancy, your body possibly could absorb or, expel any, non-viable fetus. This late in a pregnancy, you either get an infection, terrible pains. I mean, there are very few options that are not very well known to be something that you are alerted to. And this is just how it works. So if they need to call on an expert to just say no. But what Corey's doing here is, well, you could have a miscarriage and not feel it. First of all, how grand to have, this is why she should have hired a female attorney, but it turns out they didn't want to do this case. Maybe she was only able to gaslight a male attorney. Do you know what I mean? Maybe Lexi Linval was like, oh, no, I know this is BS. Well, luckily we have a female judge who can smell the bullshit from a mile away.
I do believe that that is what occurred in this case. Timing wise, I don't know if any of us will ever be able to tell exactly when that miscarriage took place. But I do know that my client from our conversations did testify truthfully, and there were not misstatements that were made there. We're certainly not intending to change her testimony. But like I said, we have spoken to experts that have identified that sort of occurrence does sometimes happen.
I'd love to see if those experts would like to testify and put their reputation on the line, that someone who's 16 to 20 weeks pregnant could actually have that happen to them.
Comments. Counsel, are you asking that I revisit the order against harassment or just for purposes of fees and costs?
Just for purposes of fees and costs, because the order was appropriate that Judge Gelketsis entered. However, she did not order fees and costs. I would contend that if she knew what we think the evidence will show, which was that Ms. Owens just lied and said she was 24 weeks pregnant with twins, and then apparently had a miscarriage apparently 2 months earlier, that had she, if any of that is true, that had she known that that was her testimony at the time, she would have ordered attorney's fees in Mr. Eckerd's favor. And I'd like that to be on the table at the evidentiary hearing.
Wow.
Okay, so then if I'm hearing you correctly, what you're saying is the separate cause number is, you think, what delineates and prevents the court from awarding fees and costs at our evidentiary hearing in its totality.
I'm not even sure if I'm right about that. I know that the court changed the rules and required us to use different cause numbers. Otherwise, it's the same parties, and it could be the same cause number. But our rules require us to have two separate cause numbers for the protective order proceeding, which has already been granted, in this tail end of a paternity matter. I'm just asking that Your Honor treat them as one for purposes of any attorney's fees and sanctions you may choose to order at the upcoming hearing.
All right. Final thoughts on that?
Your Honor, this is a res judicata issue. The issue of attorney's fees pertaining to protective orders and injunctions against harassment have already been litigated. They've already been decided. In my opinion, to the extent, well, one, I do believe that it would inhibit, I believe it's a separate case that would inhibit this court's ability to order fees unless it were to be merged, which I don't believe is appropriate with it already being over. If there were more evidence after our trial that would warrant Mr. Woodnick believing that his client would have been entitled to fees, I believe that he would need to take recourse with that judge.
He's saying, don't suck me into what happened before I was at the party.
Number and seek appropriate remedies. I don't believe it's appropriate for the court to reissue something that's already been litigated in anticipation of Mr. Woodnick's assertion that there may be additional evidence that would prove his client's claim. There certainly isn't at this point. There haven't been those things proven at this point. So I'd ask the court to deny the request.
Did either party have an attorney at that hearing?
Yeah.
Yes, Your Honor, I believe both.
Okay. All right. So then what the court is going to do is the court is going to hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition, all pleadings filed within the Maricopa County Superior Court. So everyone's on notice to be prepared to present testimony and evidence on that. Whether I ultimately award anything as it applies to that case, I can't tell you right now because I haven't heard any evidence or testimony. But I'm not going to preclude myself from that option at this point. So we'll have the minute entry reflect it so that it's clear.
Your Honor, if there was, and I wasn't present during those proceedings, but if there was an order denying the request for attorney's fees at that time, is this court setting that order aside?
No, I definitely wouldn't be, but are both parties, I recognize that the court can take full judicial notice of the entire docket of the Maricopa County Superior Court. So I don't need your permission to go look at that case, but I do think I need your permission to go watch the hearing. Do either of you object to me going and watching the hearing?
Absolutely not.
No, Your Honor.
Okay, so we'll have the minute entry reflect that between...
The judge is like, I'd like to see this hearing. Are you okay if I catch it? Because this is getting pretty good. Hey, have you seen season 2 of Jane Doe? I'm going to need to catch up on that. Oh, there's another one, Mike Maricini in San Francisco? I got to go watch that. Hey, judge, can we get the judge some Postmates so she can have some choice food? Should we get her a Factor membership and get some, 50% off her meals? Because this is getting delicious.
Between now and June 10th at 8:45, the court will review the order of harassment hearing. Do we know what date that occurred on?
The hearing dates, it was split in two. There was October 24th, 2023 and November 2nd, 2023.
Thank you. November
because that was Judge
2nd
Gelketsis'
of 2023.
And that's because our community got Clayton Eckerd, a lawyer, Woodnick here, and they're putting this bullshit to rest. Thank you to the publicly funded support from the audience that is getting to see this thing through. You almost never get to see these things through.
All right, so the court will review that between now and then, and that'll give me a little bit better idea of what authority, if any, I have. That just wasn't something I was willing to look at until I had the party's permission.
Thank you, Tricia.
Thank you, Your Honor.
Okay. All right, and then with regards...
And by the way, that's interesting that the judge can't look at it without the permission of the parties, because maybe it'll lead to some bias. But I think when you look at that, what you're going to see is that he won an injunction against harassment against her, where she had sent 500 messages and all these things. If the evidence points that she was never pregnant, or that in this case, she was for sure admitting that she found out in November that she was no longer pregnant, then maybe she should have to pay for that court fee. I mean, I almost feel like she should have to pay for my court fees at this point. I'm going to have to look into this with my lawyer. I'm actually having an epiphany right now. If she's saying in November she found out she was no longer pregnant, then how the fuck am I harassing her? Okay? How the hell is this happening if she's not even pregnant back in November, which we already knew, but now she's willingly admitting it? Do I need to sue her? Is that what needs to happen? Do we need to jump on this?
To Mr. Woodnick's request for the DNA testing and the vital records, is that disclosure you intend to present today or by the end of the week, as you talked about earlier?
DNA testing and the vital records, what exactly are you referring to, Your Honor?
If you look at page 14, I believe it was of his response to your motion, it requests the court issue an order compelling Ravegan Inc. to produce all records and documents related to fetal DNA testing in this matter, and subsection D was issue an order compelling Vital Records to produce all records and documents related to fetal death certificates under, and then the appropriate ARS for alleged twin fetuses born to petitioner.
Well, Your Honor, there isn't, to my knowledge, there isn't a Vital Records record or request that would be able to be produced because there wasn't one. Regarding the DNA testing results, that will be included. What my client
the blood is on your hands, Dave Neal.
Okay, and when is that forthcoming, today or?
It'd be by the end of the week, Your Honor. I just have to prepare. And just for the record, I believe that Mr. Eckert did participate in those with the DNA testing, so I'm not sure why he wouldn't have received those records independently as well.
He didn't get the records because Ravgen's not allowed to release them. Why do I know more about this court case than he does?
And obviously, I don't know either, but I did read in your motions that one of the results was lost in the mail, so I don't know how else that was conveyed to anyone, whether it was conveyed or not, I don't know. So recognizing that it may be moot. Yes, Mr. Woodnick?
If you can help us, smarter than the associate whispered in my ear that Jen requested you to release the information. So if Your Honor would be inclined to, since Mother's obviously now cooperating, if Your Honor would be inclined to endorse or include language in there, I'm happy to shepherd it over to Ravgen, directing them produce all records related to any DNA tests taken by or with Mr. Eckert and or Ms. Owens.
I'm going to tell you what Ravgen told me, and this is information I've already shared with you. On the phone with Ravgen, they said there was little to no fetal DNA. We asked, could it be hiding, behind a horse hoof or something? No, there's little to no fetal DNA. What's interesting is these are blood tests. Will they be able to look at those blood tests and see not just that there's little to no fetal DNA, but that her levels indicate that there is no chance she's been pregnant at any time whatsoever? This may be very, very interesting. Because how could she be pregnant and there be no fetal DNA, right? So the blood test could show that she tested positive for HCG, right? Couldn't the blood test show that? But at the same time could show that there's no DNA of any babies or anything other than her DNA. So, boy, and this is information that Ravgen can't give Clayton other than verbally, because this is a paternity test. They're just there to say, you're either the father or you're not the father. And they're saying, we don't even know the results, which means you're not the father because there are no babies. and not because she miscarried. She took these blood tests back in October, November, right? I mean, October, November, December. She took them knowing he wouldn't test positive as the father, but what she probably didn't know at the time was this would then be used against her. Maybe she thought this all would have been dismissed. This could be the smoking gun.
10 months, whatever it's been, that would be our request.
And Your Honor, for the record, I don't have an objection to that. I believe it would be an appropriate disclosure.
Okay, well, go ahead.
The other thing in our request was we had wanted mother to sign the requisite fetal death certificate, the verification, so we could get those records. I realized Mr. Heath can't testify, but is the position of mother there will be no fetal death records because none were ever submitted? If that's the case, I'll let the issue go. I'll address it at trial, but him testifying doesn't really cut it on that issue. If not, we need confirmation from the state of Arizona that there are no fetal death certificates.
And Your Honor, that is correct. And on that note, and I haven't addressed this with Mr. Woodnick, but I think it might be appropriate for us to amend our initial petition just for clarity at this point and to make sure that all parties are on the same page with what's being pled. So I would ask the court for leave to amend our petition just so that we could make these points clear in anticipation, although I do believe the discovery and her deposition will probably do that to an extent. I believe it's appropriate for us to make that clear in the pleadings as well.
And what are those intended amendments, counsel?
Your Honor, the amendments would be just outlining the new circumstances. Obviously, her petition was filed predating any sort of miscarriage or likely even a lot of the care surrounding the pregnancy. So it would be to make those things more clear. And also, Your Honor, I don't believe there were attorneys at the beginning of the case, so it would be to make sure that we're explicitly requesting attorney's fees as well.
Okay. Don't you think your motion to dismiss addressed that?
Your Honor, I think the motion to dismiss did address that in part, and it did request attorney's fees for the motion to dismiss. But if we're going to request it for the entire case, I believe amending the petition would be appropriate. I'll also note, I believe the respondent was just allowed to amend his petition a month or two prior. So I don't believe that it would prejudice anyone with us scheduling the trial out so far. I'd have no objection getting it done in a week. And if the court wants to consider our motion to dismiss a request for attorney's fees for the entirety of the case, I would be fine stipulating to that and saving the motion practice as well. And maybe Mr. Woodnick is stipulating to that.
She wants to make, if Your Honor wants to consider her claim for attorney's fees at trial, I have no issue with that. I have an issue with amending a paternity petition, which was perjured, because I don't want to be precluded from addressing the perjurous statements in the paternity petition.
I love it.
Amend it, that's fine.
He goes, I don't want to amend the petition because I don't want to be precluded to not being able to fight on the fact that she perjured herself because she said she was pregnant when she wasn't. And Corey goes, well, and amending really means to rewrite, right? He goes, why don't we just rewrite the truth? Why don't we rewrite the truth in that she was never pregnant and we can just go on out of here? We'll go to Buffalo Wild Wings for lunch. We can get bottomless Coke Zeros. We can get a little lemon wedge in there with maybe a busty waitress. We can all hang out and party, right? Let's just move on from this. Let's amend it and move it on. And Woodnick's going, whoa, hold on a second. Let's not end the party when it's just getting fun.
But I'm not ignoring, and nor do I think I have to ignore what was signed and filed with this court originally and then repeatedly prior to us coming here today. And so I don't want to lose that opportunity because mother all of a sudden realizes that stuff that she put in that petition was not truthful.
Okay. What we'll do is we'll treat the motion to dismiss as a request for attorney's fees and a motion to dismiss. Of course, I'm not minimizing that, but we will note in the minute entry, Lamar, that both sides are seeking attorney's fees and costs. And then the leave to amend based on the argument you've presented today is denied. In the event you need leave to amend for some other reason that doesn't change the alleged facts that were presented back in August, then of course I'm not precluding you from filing a separate motion to amend. I'm just denying your request as it's given to me today.
Understood, Your Honor, if I may. I just want to be clear. My intentions are not to change any of the facts that were originally pled, just to expand on the facts that were originally pled. I just want to make sure I'm clear on that for the record.
I understand. All right. Now, with regards to disclosure, since we're set out now in June and we've got the deposition March 1st, when's an appropriate disclosure deadline? I don't know how much. It sounds like everything maybe still needs to be done, but truthfully, this is not a complex case. It shouldn't take very long.
Well, I mean, there's a lot.
So I guess I'll leave this one too.
So don't know what we're getting, but if we get HIPAA responses, I guess the burden is now on us to take those HIPAA responses and go to the listed doctors that she said. I'm concerned that that's going to take some time. If she's having the HIPAA release today.
Yeah.
Do you have an inventory of what you can disclose now?
No.
Okay. Okay, that's fine. So obviously, March.
What Nick's like, if you don't point me in the right direction, I'm still going to find out where I'm going. But clearly, they're not going to do his work for him here.
1st is a pivotal day. Why don't we we'll set the disclosure deadline 30 days, Lamar, 30 days before trial. And that is, from any disclosure beyond that deadline will be precluded. However, the parties are to complete initial disclosure no later than 45 days from today's date. So that gives you guys about 30 days after the depot. And then assuming that there may be additional depots that need to be done. Are there any questions about that schedule?
Oh, yeah.
Just my last comment, and appreciative of your time. Just so the court's aware, I have every intention of taking this HIPAA release because I sent a bunch of them originally because there's a bunch of doctors that you claim. I'm just going to reproduce it and repopulate it. Is that okay, Corey?
Yeah.
Okay. All right. We'll have the minute entry reflect that Mr. Woodnick has been provided with a amended signed HIPAA release, and counsel agree that he may amend the provider.
And the date as well, Your Honor, because it requested 2018. And I'm worried that they won't accept it with me crossing off the date too.
Do you want me to sign it too? It might help.
I don't know how you want to do this, Judge.
That's okay.
I'll
Right.
defer to you, Your Honor.
No, that's fine. We'll just endorse. Who are we endorsing, Mr. Woodnick?
So they've got to re-sign it and say the judge gives permission because Corey Keith cut off the wrong, I don't know, medical provider maybe, and change the date on it.
Virtually, but can the parties send a joint email to the court with the names of those doctors? And so that I have a record of it, we will not put it in the minute entry because that is public. We'll just have the minute entry reflect, Lamar, that the court will be provided with 4 additional providers.
I think it's 4. Don't hold me to that.
And Your Honor, I think it'll be more. Just to be clear, I believe it may have been 4 then, but we'll figure out the list.
All right, we'll just have the minute entry cross out 4 and put more than 1. All right. So we've discussed disclosure, we've discussed the deposition, we've discussed all the pending motions. Mr. Woodnick, since this was your motion, is there anything you feel that the court has failed to address?
I think today was very productive. Thank you, Judge.
Thank you, Mr. Keith. Anything the court's failed to address?
I agree, Your Honor. Thank you for the court's time.
You're welcome. All right, everyone, we will stand in recess until June.
All rise.
All rise.
Oh,
Woodnick,
you can come get you stuff.
Woodnick goes, that was very productive. All right, so let's take a look at everyone's body language here. We got Jane Doe. I don't know if she feels like she won, but I know Clayton feels like he won. Woodnick's doing the metaphorical fist pumping high fives. Somehow Isabel and Corey Keith seem to be flirting here.
I
was like, who am I to tell her?
She uses it against Bell techniques.
I don't know what they're talking about.
Not to that extent.
Bunch of lawyers doing nerd things.
All right, guys, I'll be in touch. Thanks.
So
Yeah, me too.
Jane looks away when Clayton walks by. Fascinating stuff. She's the last one out of the courtroom.
Talk outside. We'll talk in the court before we.
He says we'll talk outside. Anything else? Anything else? Nope, that's it. Let me know what you think. We'll be back with more content. I'll be live on Patreon, patreon.com/Dave Neal. I'll be live on, excuse me, folks. I'll be live on Patreon after this at 12:15 p.m. Central Time, patreon.com/Dave Neal. We'll see you then. Bye, everybody.